What if I told you there's a business model that makes billions of dollars by producing absolutely nothing? No products, no services, no innovation, just lawsuits. They're called patent trolls. And right now, they're probably suing someone you know. These companies have extracted over $30 billion from the tech industry. They almost killed BlackBerry. They tried to own podcasting, and one man beat them 35 times in a row. This is their story, and his. The term patent troll isn't official. Lawyers prefer non-practicing entity or NPE, but the business model is simple. Step 1. Buy vague patents for cheap, often from bankrupt companies. Step 2. Wait for successful businesses to launch products that might even loosely relate to your patents. Step 3. Sue them. Most companies settle rather than fight. Litigation costs millions. Settlements cost less. The trolls count on that math. 2006, BlackBerry was the smartphone before smartphones. Every executive, every politician, every power player had one. Then came NTP, a company with 8 employees, no products, no services, just patents. NTP claimed BlackBerry's entire email system infringed their intellectual property. The patents were questionable at best, but a Virginia jury didn't care. They sided with NTP. The verdict threatened to shut down BlackBerry completely. Here's what NTP actually owned. Patent 6067, daarvan voorschotvertrouwen, electronic mail system with RF communications. Sounds specific, but the claims were incredibly broad. So broad that the US Patent and Trademark Office later invalidated them. But later doesn't help when you're facing an injunction. The court documents show BlackBerry's impossible choice. Shut down the network serving millions of users or pay. They paid $612.5 million. NTP was just the beginning. By 2015, patent trolls were filing over 3,000 lawsuits per year. The targets weren't just big tech. Coffee shops using Wi-Fi, hotels with websites. Anyone using any technology became a potential victim. Studies estimate trolls cost the American economy $29 billion annually in direct costs alone. That's money not spent on innovation, jobs, or actual products. Enter Cheng, Chief Legal Officer of Newegg, the computer hardware retailer. When trolls came knocking, most companies paid. Cheng didn't. His philosophy was radical. Fight every single case, no matter the cost. Win or lose, never settle. His reasoning? Settlements just encourage more lawsuits. Only by defeating trolls in court could you actually stop them. It was expensive, it was risky, and it worked. 35 patent troll lawsuits, 35 victories, 0 settlements. Cheng's record became legendary in tech circles. Trolls learned to avoid Newegg entirely. Why sue someone who will definitely fight back? Each victory set precedents that helped other companies. Each case exposed the trolls' weak patents. Newegg spent millions on legal fees, but they saved the industry far more by showing that trolls could be beaten. The court records tell remarkable stories. In one case, a troll claimed to own the concept of the shopping cart icon. In another, the invention was accepting credit card payments online. Each time, Newegg's lawyers proved the patents were either invalid or didn't apply. The documented evidence shows trolls often couldn't even explain their own technology. They just bought patents and hoped nobody would challenge them. Then they tried to own podcasting. Personal Audio LLC, they claimed to have invented podcasting. Their patent? A system for distributing episodic media online, filed in 1996. Every podcast you've ever heard, they wanted a cut. They sued Adam Carolla. They sued major networks. The podcast industry faced extinction before it even fully existed until the Electronic Frontier Foundation stepped in. The EFF crowdfunded a legal challenge to Personal Audio's patent. They argued the patent was invalid, that prior art existed before 1996. They won. The Patent Trial and Appeal Board invalidated the podcasting patent. Millions of podcasters, including this one, owe the EFF for saving their medium. The court documents show exactly how weak the trolls' claims really were. 2014. The Supreme Court delivered the death blow to many trolls. Alice Corp versus CLS Bank. The ruling: you can't patent abstract ideas just by adding on a computer. Thousands of software patents suddenly became worthless. The USPTO started rejecting applications that would have sailed through before. Court documents show patent troll lawsuits dropped 40% within 2 years of the Alice decision. Patent trolls haven't disappeared, they've adapted. Instead of broad software patents, they now focus on telecommunications, medical devices, and emerging tech like AI. The game continues, just with different pieces. But the victories of Cheng, the EFF, and the Alice decision proved something important. Trolls can be beaten. It just requires someone willing to fight. If you're building something, a startup, an app, a business, you might face a troll someday. The lessons from these battles are clear. Vague demand letters often come from trolls. Check if the suing entity actually makes anything. And remember, sometimes fighting costs more than settling, but it stops the next lawsuit. The patent system is supposed to encourage innovation. Trolls abuse it to tax innovation. Cheng retired from Newegg, but his legacy lives on. The EFF continues protecting digital rights. And every time a company stands up to a patent troll, they make it harder for the next shakedown. The patent system still needs reform, but thanks to these battles, innovators have better tools to fight back. Sometimes the best defense is showing that you're willing to fight. Patent trolls abuse a broken system. But what happens when the system itself becomes the weapon? In our next investigation, we expose how Google became a monopoly and the court documents that might break them up. The DOJ called it the most important antitrust case in a generation. Subscribe and enable notifications to see the evidence that could reshape the entire internet.